Yes, sir. Arlene, you're good?
Yes, sir.
So we're hearing cause number 187-3327, State of Texas versus Franklin Peña. Just want to make sure we have, okay, got the interpreter, got him out. That's good. This morning I filed an amended order concerning extrajudicial statements. I believe everybody has a copy, has had a chance to look at it. I wanted to make sure something was put in place in writing fairly quickly. Obviously, as the last sentence says, this can be amended, things can be added to it if need be. But I think this, at the very least, covers all of the rules of professional responsibility, penal code, code of criminal procedure, rules of evidence, and other requirements of all lawyers, and then there's certain aspects that apply specifically to the state. And it does include verbiage that this applies to all former, current, or future lawyers and their staff that have anything to do with this case. Obviously, in the case of the district attorney's office, that's a large law firm, so it would include everybody within that office, previously, currently, or in the future. And for the defense, anybody who is formerly, currently, or in the future employed or touches this case, so to speak. In terms of limiting speech or communications of people other than the lawyers and employees of the law firms and stuff like that, as we get closer to trial on the eve of picking a jury, things like that, it gets very easy legally to limit all kinds of communication. If it is necessary to preserve the integrity of these proceedings, to do so sooner, I am all ears and I will listen to whatever requests are made. I just wanted to make sure something was put out in writing so we could at least have something now as a placeholder for whatever may come in the future. But any questions, I guess, about the protective order first before we jump into any other things?
I do have some questions.
Okay.
Judge, I would first, and I think counsel will agree with me on this, to be clear,
Okay.
I still believe that former District Attorney Kim Ogg was covered under the prior order, okay?
Yes.
And the need to clarify this essentially for her, okay? Doesn't negate the responsibility she had under the old order, just to be clear about that. My
Yes.
continuing concern with what Your Honor has entered, and perhaps it can be resolved by some sort of, I'd ask the court to consider some sort of oral amendment, is this. It is on pages 4, number 1, second sentence under number 1, the phrase "or to be involved." Page 5, number 2, line 3, the phrase "or to be involved." And page 6, the first full paragraph after number 5, the phrase "or to be involved." It is possible to read this that a witness, someone who is not now a witness and has made a statement to the media and then becomes a witness later on, and we don't know, okay, could theoretically be subject to a show cause order because of the language "to be involved." So that is why I had suggested to the court, and I think Your Honor has the copy of what I previously submitted as my proposed revised, and I'm happy to provide this to the court again, and I ask the court to at least, if not interlineated on this, to state this orally. We drew a distinction that witnesses who give statements to law enforcement personnel, representatives of the Harris County District Attorney's Office, or who testify in investigative or adjudicative proceedings after the date of entry of this order shall not discuss the case with the media. So the distinction I was trying to draw was you can say, they can say whatever they want until they become a witness. At that point, this order kicks in.
Okay. I think if I'm,
So
Reading this.
now, I may be misinterpreting what you're on.
I don't think this the bullet points that you brought up, I don't think it mentions witnesses. It just discusses attorneys, their offices, staff, employees, interns. So it goes specifically to the lawyers and their teams, for lack of a better word, and does not discuss the witnesses specifically. Oh wait, never mind.
It does in number 2.
It does in number 2. So you'd be requesting a definition of witnesses, or when that kicks in for witnesses, for clarity's
Yes,
sake.
or something like that. And again, can I approach, I'll give you what I
Absolutely,
previously said.
absolutely.
Before, and you have a copy. So what I'm looking at is, the distinction I was drawing was on number 3 and number 4.
Okay. And this is from the state's proposed
That was the
previous
yes,
order,
Judge.
page 8, 3, and 4.
But to be clear, whatever you sign today and enter, I will send an all-employee email.
Sure. Is there any objection from the defense to me orally saying that witnesses who have previously given statements to law enforcement personnel or representatives of the Harris County District's office, attorney's office, or who have testified in investigative or adjudicative proceedings would be prohibited from discussing this case with the media? Is there any objection to including that to the order?
No.
Okay, so I can orally say, yes, I'm okay with including that within the order, with the caveat of if they do wish to make a statement, we need to have a discussion because we're limiting First Amendment rights. So I would need to make it clear for the purpose of the record and for this order to need it, that that is adjustable should they want to discuss that and want to exercise their First Amendment rights. We have to litigate that again. So
All right, so
I agree to that, but with the caveat that it would be without permission of the court. So if the court gives permission, then they would be able to make statements. So they affirmatively have to ask. If they do, we'll discuss it, all of us. So yes, as to page 8, numbers 3 and 4, I would incorporate those orally into the amended order that I've got today.
okay.
And I guess with that caveat, what I would ask is that the district attorney's office then be pretty careful about what sensitive information they share with witnesses, family members, things like that. Because I wouldn't want that to be an end around to the court's order.
And the court's order obviously limits the lawyers, and I'm going to say teams for just lack of a better word because I don't want to have to say employees, interns, everything a million times over. That would include you could not use a third party to do the same. So telling somebody information that they then disclose, if you know they're going to disclose it, or it's reasonable to believe that they're going to disclose it, at the very least tell them you can't disclose this. It could impact the integrity of this proceeding and could have potentially a harmful impact on the eventual trial of this case. So let your witnesses or other people involved make sure they're aware.
This administration understands its professional responsibility.
Absolutely. Any other questions so far as to the amended order? make sure that the one that I signed this morning is filed. I've made those oral amendments, and perhaps if necessary, I could include them on an additional amended order should it need be, but for the time being, we have a transcript, we will have a transcript of this proceeding, it's there.
Very good.
All right.
Thank you, Your Honor.
What else do we want or need to discuss today?
Your Honor, if we can, regarding our client, we concur with all that. We don't see any reason to proceed unless you want to, but we're in agreement.
Okay. So this is as to Mr. Martinez Rangel's case. Let me get the cause number so we can have this for the record.
I believe his cause number is 1873328.
Yes. So as to that cause number, defense counsel wants an identical order with the identical oral admonishments, but with Mr. Martinez Rangel's name and cause number applied.
That's correct, Your Honor.
I will make sure that order gets filed today as well. It'll look identical, but for the purposes of this proceeding, those same oral additions or amendments will be incorporated into that document as well. All right?
So I guess the only thing outstanding is direction from the court on the contempt hearing itself.
Sure. So I have thoughts and potentially questions. One, I believe that there was discussion of state bar grievance being filed that contained similar, if not identical, subject matter from both sides. Have those been filed? Are they going to be filed? Do we know? Is that something that we're comfortable discussing?
You're putting me in a tough spot, Judge.
Okay.
Because it's a confidential proceeding.
So without going into whether or not it's been filed, would anything that happens here on identical subject matter stop those proceedings, or vice versa? Would state bar grievance proceedings on the same subject matter potentially stop this court from proceeding should one resolve before the other? Do we know?
I don't think so, because one's criminal, one's administrative.
Okay.
We're in agreement on that assessment as well.
That's one of the things I thought. If it were filed, which I know because those proceedings are private in nature, unless there was a public reprimand, a suspension, disbarment, something that happened in the public eye, the results would also be private, so we would not, it might not make sense to wait for that process if one exists to play out before discussing contempt here. So the relief requested by both parties in their, I believe the defense filed a motion and the state filed only an order, the defense filed an order as well. I believe that the only relief requested was criminal contempt, not any of the other powers that this court might have, such as requiring education or other sanctions. So I have to think about, I believe that in order for contempt proceedings to proceed, there has to be a motion and has to be an order. There is a motion, but I believe the motion does not include other powers that the court may have. So I'm a little hesitant at this time to sign off on either order, but in the same vein as the grievance, I know there's in my order reference to 3906 and there are other things. Does criminal contempt stop any other potential avenues, not including state bar grievances, from proceeding? Because it is criminal in nature.
No.
Okay.
Here would be the distinction, Judge. For and I would ask Ms. Schultz to chime in as well.
Sure.
For civil contempt, okay, what you are basically doing is you are enforcing compliance.
Okay. I thought this was requesting a criminal contempt.
This is so for civil contempt, right? Like you just you didn't show up at court, right? you are, in essence, you're fining the person, right, in order to come into contempt, in order to come into compliance. Criminal contempt of a court order, a criminal contempt of court is either direct or constructive. Direct is in front of you.
Yes.
Right? Constructive is outside of the courtroom. Right? You are enforcing, not compliance, you are enforcing non-compliance with a specific order of this court, of you. It's not so it is punishable by fine and no jail time, but it is also punishable by jail time. I think what's up to 30 days?
I believe so.
Right. And what is the $5,000 fine? $3,000?
I have to check.
Yeah.
Judge,
So,
agree, but for criminal, it's punishing not following the rules, and civil would be enforcing for the future. So criminal would be punishing for what has already happened.
Okay. And I guess for practical purpose, the whole reason we're here discussing a protective order and contempt is everybody involved. The court, both sides, are trying to do everything possible to protect the integrity of the proceeding so that everybody's goals can be accomplished. We want to make sure that the state has a fair opportunity to present the case they want to present, as well as the defense to have a fair opportunity to litigate the case the way they see is in their best interest, without outside factors, outside influences, or additional unneeded media attention or other attention that could potentially impact the jury pool, force a change of venue, or set up error before trial even begins. I don't think we've gotten there yet, obviously. I think we're in a good position. I think that things are still fine. But from a practical perspective, I have concerns that at this time, a contempt proceeding potentially could draw more unwanted attention, give an additional, I guess, microphone to parties involved to potentially taint or complicate proceedings at this time. The old order that I'd signed on September 11th, my intention, and I believe it could be read as such, was that it applied to everybody whether they maintained their employment or not. And I think that the rules of professional responsibility make that crystal clear. I do see how it could potentially be read otherwise. I know the last hearing and today again making it clear my intention and my reading and my understanding of what I signed was that it did apply even after leaving employment, because it cites the rules, and those rules are very clear that you leave government employment, those same rules are in place. But at this time, since a new order is in place, I want to hold off on signing a show cause order today to see if this new order potentially solves the issues, as well as I just want to make sure that other claims are not as stopped, or that other powers the court may have in terms of sanctions or other things are not limited or unavailable if I sign off on the specific show cause order that either side had filed or some cobbled together version of both. So it's not a no, it's a no for today. So the court could perhaps be a little more comfortable with what is available. I do want to make sure that this new order is disseminated to anybody that either side believes needs to be made aware of its existence. Clearly, because we've discussed it, Kim Og herself, and I know there's been reference to first assistance among other things. So I want to make sure that that has been received. But any questions, commentary, requests at this time. Obviously, everything we're doing today can be relitigated as things advance.
Yes, Judge. Just to clarify, because if we're thinking of it as an injunction, that would be for civil contempt, and that's not what we're asking for. Because what I believe what the court is saying is, does this fix any future problems? And that would be civil. And we're asking for criminal punishment for statements that are already public. So we don't believe that it would further bias beyond what's already happened.
However, Judge, at this point, we have a duty to protect our client's Sixth Amendment rights. As you recall, in the September 11th order, you have the exact same language, pretty much. The court shall consider sanctions and as appropriate for violations of this order. Even in our hearings where we were operating under oral orders, you made it very clear that the district attorney's office was to report back to former Democratic District Attorney Kim Ogg that these orders were punishable by contempt. And so if we're looking at both the civil side of it and the criminal side of it, the court has actually probably done the civil side by issuing a more clarified order, but it has not addressed the violations of the previous order. And that's very concerning to us because ultimately if the court takes an overly cautious position on this issue, I can't see a scenario where the former Democratic District Attorney decides that, well, the court isn't going to sanction me, so why should I follow this order?
And Judge, we filed a supplemental motion last night
Okay.
detailing 2 interviews that she, former District Attorney Kim Ogg, has given in the last week or so.
Okay.
One was to the Houston Chronicle, and one was an appearance at the Kingwood Tea Party meeting, I believe on Monday night.
Okay.
We included their flyer in there, and they billed it as something to the effect of, well, they can issue a gag order, but they can't gag us, or something to that effect. And so she references the case that she can't talk about, bringing more attention on it, being cute and flippant about her past violations of the court's order.
And I have not had an opportunity to review that.
Judge, can I say something?
Absolutely. Absolutely.
With all due respect, I don't disagree with anything as to how necessarily you framed the matter before you. I take, however, something of a little bit of a different perspective as to what the true issue is before you.
Sure.
And this is, I'm quoting now from the Chronicle, Houston Chronicle's reporting of Kim Ogg's speech to the Kingwood Tea Party. Quote, "Now, I've been silenced by the court on that case. When I gave interviews a few weeks ago, I was not under a gag order," Ogg said. "Now I am. So we'll leave it to the fact that I'm against the rape and murder of little girls. Are you?" No person, no attorney can breach a court order. Okay? I submit to you that Kim Ogg giving a speech and saying, "I was not under a gag order," is Kim Ogg flipping this court the proverbial bird. All right? And what she did, and it's their motion, we're unopposed, it's a very unique situation, right? What she did is, in my opinion, quintessential contemptuous behavior. And no licensed attorney in the state of Texas should be able to avoid a contempt proceeding for violating a court order and for leaking confidential information
about an ongoing criminal investigation. Full stop. So,
Yes.
I understand the court's concerns. They are weighty. And to be clear, this is not a situation that any of the counsel around you have created. Okay? This is a situation created by an extraordinarily selfish human being who believes that the orders of this court do not apply to her. So I look at this situation somewhat differently than Your Honor. I do not believe that any proceeding, should you decide to undertake one, would interfere with the state bar's issues, an examination of what has been conducted, what has occurred, and any grievances that may have been filed. Nor do I believe it would preclude any possible future actions by this court or by this office. I cannot fathom a scenario more serious, or quite frankly, more necessitating a contempt proceeding than this one.
And I will say what was just brought to this court's attention does change the tenor of things. It sounds like, and I obviously have not read the June 17th filing, I will take time to read it and all attachments, but it sounds like the allegation is that the former district attorney acknowledged notice and receipt of a protective order limiting speech, and upon acknowledging it, then spoke in violation of the order she just acknowledged existed. So I know I have this order against me. Let me violate it by saying these things. Is that what is alleged?
I mean, again.
More or less?
I mean, here's what she said. Now, I've been silenced by the court on that case. When I gave interviews a few weeks ago, I was not under a gag order. Ogg said. Now I am. So we'll leave it at the fact that I'm against the rape and murder of little girls. Are you? So again, here's an individual who now says, I understand I'm under a gag order, but I'm going to opine again
Yes.
on their guilt and innocence. This is a licensed attorney in the state of Texas, board certified, more than 36 years. Okay. Judge, you need to hold a contempt hearing.
Understood. So every word after "now I am" is an opinion on the case being
Correct.
made in a public forum.
Correct.
And there are other statements and acknowledgments.
And it just piles on.
And I believe that she's going to continue to do this. My goodness, she was doing this Monday night.
My initial concerns were twofold. Obviously, stopping any future inappropriate communications, as well as addressing previously made statements that were in violation of court orders and or state bar rules. My biggest concern was if we are to try to maintain or limit any potential taint on this proceeding, that by shedding more light and giving a stage to somebody who might speak out more and more might complicate things or exacerbate where we're at. But what it sounds like is both sides believe, and I'll read this filing, it sounds like it indicates that even after knowledge of the order, statements are still being made. So whether there's a contempt hearing or not, these statements are going to continue to be made, and any taint, if any exists, having a contempt hearing is not going to make it any worse. So in light of that, I do need to reevaluate that. Because if statements are made after acknowledgement of it, that one concern, frankly, is not as much of a concern anymore.
And frankly, that was our thought process in December,
Exactly.
before she left. And what we were incorrect about was that, oh, she's leaving office, she will move on to her next endeavor and not continue to taint this case with her comments to the media. We were wrong about that. And I think her Houston Chronicle interview and her appearance at a political function on Monday night only served to underscore that again, that she is going to continue to use this criminal case to launch her next political career or whatever her motivations are. And she's not going to stop until someone makes her stop.
Judge, I can't speak to what her future aspirations, the former district attorney's future professional or political aspirations are. Quite frankly, I don't care.
Yes.
What I care about is I have a former member of the prosecution team continuing to violate this court's gags order and complicating the prosecution of an extraordinarily serious case. And as the chief legal officer, general counsel of the office, I can't tolerate that.
What I'm hearing is the state of Texas effectively has an ultimate goal of prosecuting this case and attempting to see that Mr. Peña and presumably his co-defendant are executed. The defense obviously has the opposite goal, but it is the state's position that their ability to do that gets more complicated when a former member of the prosecution is undermining their ability to proceed the way they believe they need to proceed without extra, unnecessary, or inappropriate attention, as well as bar rules being broken, more light being shed on that, and effectively a previous member of the prosecution, former DA, claiming they want, I guess, the harshest of punishments while acting in a way that might undermine the state's ability to get there.
I would characterize it as the purposeful and selfish violation of due process.
Okay.
And I would also say with regard to the court's concerns about the status of a bar grievance or other prosecutions, from the defense perspective, while those things might be nice, our only goal here is to protect Mr. Peña's right to a fair trial, and that has to supersede all other concerns about how it may affect collateral proceedings.
Absolutely. Both sides want a fair trial where the rules are followed. Both sides want to fight hard and fight fair. State wants to see the ultimate sentence. Defense does not want to see that. And the only way that the proceeding can happen correctly is if both sides and the entire process is handled appropriately, fairly, everybody following the rules, so whatever happens at the end of the day is lawful and appropriate. So I do think I need to reassess. I'm going to read the filing from last night and let me see what I can cobble together and consider. If I have any further questions, because there's a couple of things I want to look into, I will reach out to both sides and we can discuss. Just thinking, I understand civil contempt does not preclude potential criminal proceedings. I'm concerned that criminal contempt potentially could, and I don't know if that is something that the sides have thoughts on or would be comfortable with, but let me do my own looking into that, and if both sides have thoughts or,
My suggestion is this, is that when I'm volunteering Ms. Schultz, she and I will, I think over the next hour or two, try to email you and staff counsel, some pertinent cases, but there's a big distinction between civil contempt and criminal contempt.
absolutely.
And Judge, we would re-urge the motion that we've already filed, especially since the court has stated that attorneys who previously worked for the old administration, not the current one, were under the protective order, or gag order as she calls it. So the state can choose, since they're the prosecuting attorneys here, which specific instances to go forward on. The court would not be making a finding by allowing us to proceed on that at this time. The court would be allowing us to try to prove it. So if the court would give us the opportunity to do that, I do think that the May statements specifically should be prosecuted as well.
So in theory, if a show cause order were signed, proceedings began to be able to litigate and get to the bottom of things, if a finding is not made or is withheld for the future, nobody's precluded from doing anything or stopped from doing anything because no finding has been made. So
Yes,
at
sir.
least give you all the chance to litigate. Is that what I'm more or less hearing?
Yeah, yes, but again, I think that Schultz and I do disagree. I think
Yeah.
with regard to the proposed order that they gave you last time, I do not think, I understood there was a check mark for this or not for that.
Yes.
I get it. I don't think there was sufficient notice there. And I also think, honestly, even what I gave you now is going to have to be amended because
Yeah.
the statement, now I am, so we'll leave it the fact that I'm against the rape and murder of little girls or you, would constitute a violation of the gag order.
Judge,
Old one and new one.
just to have the schedule kind of in front of the court and on the record, we already have a July 28th date set. I believe the court would have, I'm not trying to schedule the court, but I do believe that there would be more than ample time to give the former district attorney notice, more than 30 days notice at our current rate.
Sure, it's Juneteenth today. It's almost roughly 40 days.
I just think we need to get started, Judge.
Yeah, let me accelerate my process on this and see if I'm comfortable signing a show cause order quickly. And if I have questions or anything like that, I'll reach out to both sides. I just want to make sure everything is done meticulously. So, anything else to put on the record today?
No, Judge.
Thank you, Judge.
Thanks,
Thank you.
man.
For sure.
Thank
Good to see all of y'all. Oh, Mr. Reeves, if you want your
Actually, Judge.
file, and I poorly took notes with my left hand as to.